Hello, welcome to UGC E-Padashala project. I am Ranjit Thomas, working as an assistant professor of law at National Law University, Jodhpur. Today, I am discussing about the topic Jurisprudence of Sentencing Function under the paper Penology and Sentencing. Learning objectives of this module are: first, to give a basic understanding about the importance of sentencing in the criminal justice system. Second, to understand the importance and use of judicial discretion in the sentencing system. And third and the last one, to understand the jurisprudence of sentencing function. We know that punishment and sentencing occupies an important place in the administration of criminal justice system. Safeguarding the society by preventing the crime and deterring the criminal is amongst the primary purposes of criminal law, and this can be achieved only by imposing an appropriate sentence on the offender considering the social concerns of the members of the society. While punishment is a matter of substantive law, the process of sentencing is a part of procedural law. It means punishment is what is prescribed by the legislature for a prohibitive conduct, whereas on the other hand, a sentence is the award of actual punishment to the convict by the judge upon exercising his judicial discretion, after considering the facts and circumstances of each particular case. In almost all the jurisdictions, the legislature determines the prohibitive conduct and would try to prevent the same by passing a general law or a specific one. For this reason, it prescribes the punishment. However, awarding the most appropriate sentence to an offender found guilty is amongst the most arduous and tedious tasks in the administration of criminal justice system. Before moving to the jurisprudence of sentencing function, we will see what are the different types of sentencing schemes in various jurisdictions. During the last several decades, sentencing practices in most countries have undergone transformation. There is disagreement, however, about the number and types of sentencing system currently used. Furthermore, new sentencing schemes continue to be proposed. The following types of sentencing schemes are used in most jurisdictions. The first one is indeterminate sentencing, second, determinate sentencing, third one, presumptive sentencing, and fourth, mandatory sentencing. Beyond those four categories, other hybrid sentencing schemes have been devised. Out of four, first is indeterminate sentencing. Indeterminate sentencing is a system of sentencing in which a legislature establishes maximum and minimum terms for each crime, and a judge makes a discretionary decision as to what the maximum and minimum sentences should be for each convicted offender. For many decades, the most frequently used form of sentencing was indeterminate sentencing. Indeterminate sentencing involves setting explicit upper and lower limits on the amount of time to be served by the offender with one's early release date determined by a parole board. Second is determinate sentencing. Determinate sentences require a fixed period of confinement with possible reduction for parole. A legislature fixes the terms for particular crimes, thus taking away the sentencing discretion of judges. Under determinate sentencing, the judge still makes the decision of whether or not the offender goes to prison, but discretion as regards the decision as to the length of sentence is taken away from the judge. Third is presumptive sentencing. Presumptive or guideline-based sentencing is a specific sentence usually expressed as a range of months for each and every offense or offense class. The sentence must be imposed in all unexceptional cases, but when there are mitigating or aggravating circumstances present, the judge are permitted some shortening or lengthening sentences within specific boundaries. Aggravating circumstances are those factors that may increase the severity of punishment, whereas mitigating circumstances are those considerations looking at which the judge may reduce the severity of the punishment to be given to a convicted person. Judges weigh the mitigating and aggravating circumstances involved in an offender's conviction offense. If the aggravating circumstances outweigh the mitigating ones, the judge is justified in increasing the severity of the sentence. However, if the mitigating circumstances predominate, the judge may exhibit greater leniency. Judges have considerable discretionary power at the time of sentencing offender. How particular circumstances may be evaluated, however, is highly individual and depends on subjective factors and the facts and circumstances of each case. We can see that some judges may impose especially harsh sentences even though there may be extensive mitigating circumstance. The last one is mandatory sentencing. Mandatory sentencing law denies judges their power of discretion. Judges can't reduce the term of offences that carry prescribed mandatory minimum sentences, and they are restricted from imposing alternative sentences in the community. Mandatory sentencing is the imposition of an incarcerative sentence of a specified fixed length for certain crimes or certain categories of offenders as decided by the statute, in which no option of probation, suspended sentence or immediate parole eligibility exists. Usually, mandatory sentences including life imprisonment are prescribed for most serious crimes such as murder, dacoity, rape, etc. Punishment and sentencing in India. In India, we can see that the scheme of punishment is provided under section 53 to 75 of the Indian Penal Code. Types of punishment as per section 53 of the IPC are death, imprisonment for life, imprisonment that is of two types, namely rigorous, that is with hard labor, and simple, forfeiture of property, fine. The only provision under the Indian Penal Code which prescribed for mandatory death penalty was section 303, which has been struck down by the Supreme Court in the case of Mithu versus State of Punjab as being unconstitutional. Correspondingly, section 28 and 29 of the CRPC deals with the sentences that the High Court, sessions judges and magistrates are empowered to pass. The CRPC provides for wide discretionary powers being conferred on the judges as regards the stage of sentencing after he has found positively in regard of the accused as having committed the offence he was charged with. Section 235, 248, 325, 360 and 361 of the code are dealing with this concept. Section 235 of the CRPC is vesting sentencing power with the Sessions Court, and correspondingly section 248 of the CRPC vests sentencing power with the magistrate courts. Section 360 of the CRPC is the best example of the vesting of wide discretion in criminal justice system on the convicting judge to release the offender on probation if he is found not to be a serious threat to the society. The object of this provision is to give the convicted person the opportunity to bring to the notice of the sentencing court the mitigating circumstances and to state aggravating circumstances. This will ultimately aid the court to make its choice as regards the appropriate sentence by using the wide range of discretion in the matter of sentencing. Only after giving due weightage to the mitigating and aggravating circumstances placed before it, the court will arrive at the sentence. The Supreme Court, in the case of Rajendra Prahlad Rao Vosnik versus State of Maharashtra, reiterated that every case has to be decided on its own merits. The judicial pronouncements can only state the precepts that may govern the exercise of judicial discretion to a limited extent. Justice may be done on the facts of each case. These are the factors which the court may consider in its endeavour to complete justice between the parties. The court then would draw a balance sheet of aggravating and mitigating circumstances. Both aspects have to be given their respective weightage. The court has to strike a balance between the two and see towards which side the scale or the balance of justice tilts. The principle of proportion between the crime and the punishment is the principle of just deserts that serves as the foundation of every criminal sentence that is justifiable. In other words, the doctrine of proportionality has a valuable application to the sentencing policy under the Indian criminal jurisprudence. Thus, the court will not only have to examine what is just, but also as to what the accused deserves, keeping in view the impact on the society at large. Every punishment imposed is bound to have its effect not only on the accused alone, but also on the society as a whole. In another case of Hazara Singh versus Rajkumar, the Honorable Supreme Court has observed that it is the duty of the courts to consider all the relevant factors in order to impose an appropriate sentence. The legislature has bestowed upon the judiciary this enormous discretion in the sentencing policy, which must be exercised with utmost care and caution. The punishment awarded should be directly proportionate to the nature and the magnitude of the offence. The benchmark of proportionate sentencing can assist the judge in arriving at a fair and impartial verdict. Supreme Court further observed that the cardinal principle of sentencing policy is that the sentence imposed on an offender should reflect the crime he has committed, and it should be proportionate to the gravity of the offence. Supreme Court has repeatedly stressed the central role of proportionality in sentencing of offenders in numerous cases. If you see the aims, purposes or goals of sentencing, sentencing is the stage of the criminal trial where the judge decides the actual sentence to be awarded to a convicted offender. Therefore, it is very important for the judges to keep in mind what end they are trying to secure by awarding the particular sentence to the offender. Goals, purposes or aims of sentencing occupies an important place here. In India, neither the substantive or procedural criminal law gives any clear-cut idea relating to the purposes of the sentencing process, except some judicial decisions in this regard. Some of the important goals of sentencing are the following. The first one, to promote respect for the law, to reflect the seriousness of the offence, to provide just punishment for the offence, to deter the offender from future criminal conduct, to protect the public from the convicted offender, and to provide the convicted offender with educational and vocational training or other rehabilitative assistance. On a perusal of the judicial decisions and the worldwide literature existing in this regard, we can deduce that the main purposes of sentencing are fivefold: denunciation, deterrence, rehabilitation, protection of the public, and reparation, that is victim restoration. The objective or purpose of sentencing is based on the crucial question: why do we punish, whom do we punish, how much do we punish, and finally, what punishment should be imposed. At the same time, it is the duty of the sentencing judge to look into the future and select or identify the sentence which is likely to have most impact on the individual. The most important function of sentencing is to punish the offender and to prevent the crime. But if we analyze the process of sentencing in-depthly from the point of view of the administration of criminal justice, we will disagree on this premise, as sentencing has other functions such as normative, distributive, preventive, etc. So, the first one we are analyzing is the normative functions of sentencing. The normative function of a sentencing system is to assure that an individual convicted of a crime should receive a sentence which they in principle should receive. Retribution and just deserts theory are mainly serving this end. Vengeance, expiation or denunciation are the different facets of retribution, but Vengeance and expiation as objectives of sentencing are rejected by the modern penal jurisprudence. Nowadays, expression of a community's condemnation or denunciation is considered to be one of the most important purposes of sentencing. The denunciation theory emphasizes the society's disapproval of wrongful acts and restores or reaffirms the values violated by their acts, and thereby declares that the society will not tolerate their wrongful conduct, regardless of any future deterrent effect. At the same time, it upholds the social cohesion and reassures the society that its rules are being enforced. The second is distributive function. Distributive function of sentencing, the principal distributive functions of sentencing are promoting consistency and fairness in the sentencing process. The sentencing judge enters into deciding the sentence based on different variables, including the characteristics of the offender and the severity of the offense, mainly in the form of aggravating and mitigating circumstances. While sentencing, the principle to be kept in mind or to be followed is that sentences for similar offences committed in similar manner should be same. But this does not mean that there should not be any disparity in the sentencing process. Identifying warranted disparities and rejecting unwarranted disparity is the main function of any sentencing system. The High Court of Australia analyzed the root causes of discrepancy in issues of sentencing in the case of Wong versus Rand, and it identified that the reasons are increasing number of cases, growing size of the judiciary, and number of judges. Discretionary power in sentencing and absence of sentencing guidelines. The Apex Court of India in a cantina of cases has clearly held that there is no unanimity among the various high courts interjurisdictionally and even intra-jurisdictionally as to what are the mitigating circumstances and aggravating circumstances for a particular offense, and this most of the time ultimately leads to a situation where we can spot the lack of fairness in the sentencing process. Critics point towards the conferment of unrestrained discretion as the main reason which results in disparity in sentencing. They contend that judges who are not bound by sentencing rules or guidelines, but who are rather free to fashion sentences as they deem appropriate, often impose different sentences on similarly situated offenders or identical sentences on offenders whose crime and characteristics are substantially different. As Judge Mervyn Frankel charged in his influential book Criminal Sentences, Law Without Order, unstructured discretion leads to lawlessness in sentencing. Allegations of lawlessness in the sentencing process reflect concerns about discrimination as well as disparity. Although these terms are sometimes used interchangeably, they are significantly different. The bleeding issues, inconsistency and unwarranted disparity is ultimately end up with lack of fairness in sentencing. Third is preventive function of sentencing. The primary function of criminal law is in every society is to help to maintain the social order by deterring the criminal behavior of its subjects. The preventive function of sentencing is helping to achieve this end, and mainly it can be seen working in a threefold manner. Firstly, it does so by deterring the actual offender and prospective offender from engaging in future criminal conduct. Secondly, by incapacitating and thereby protecting the public and collective interest of the society. And thirdly, by rehabilitating the offender. The first one under preventive function of sentencing is deterrence. While sentencing an offender, one of the main aim is to not only to punish the actual offender, but at the same time by showing the painfulness of the prospective punishment to be met out to deter the potential offenders. from engaging in similar acts amounting to criminal conduct. But the main aim is to dissuade or deter an offender or members of the community from committing a similar crime in the future. Deterrence mainly operates in the following dimensions: individual deterrence or specific deterrence, general deterrence, and educative deterrence. Individual deterrence or the specific deterrence is mainly revolving around the effectiveness of punishment or sentencing as regards the particular offender's future conduct. On the other hand, the principle of general deterrence aims at using sentencing as an example to deter other people from committing the same crime. The Honorable Supreme Court of India, in its decision in the case of Mahesh versus State of Madhya Pradesh, while refusing to reduce the death sentence of a convicted offender, observed that importance of deterrence as a sentencing function. I quote, "It will be a mockery of justice to permit the accused to escape the extreme penalty of law when faced with such evidence and such cruel acts. To give the lesser punishment for the accused would be to render the justice system of the country suspect. The common man will lose faith in courts. In such cases, he understands and appreciates the language of deterrence more than the reformative jargon." Unquote. We will analyze the second objective under preventive function of sentencing, that is incapacitation. To protect the public from offenders who may pose threat to their welfare and safety is an declared object of punishment and sentencing, and that can be only achieved efficiently by imposing appropriate punishment. With some offenders, principles of neither deterrence nor rehabilitation theories will work. Therefore, it is the duty of the administration of criminal justice system to incapacitate the offender by rendering the criminal incapable of committing the crime in future. In the olden days, it was death penalty, mutilation, or deporting the offender outside the colony. However, nowadays, death penalty and imprisonment are mainly occupying the space. But the main concern with incapacitative sentence was determining whether the sentence imposed will turn out to be longer or more severe than that which would normally be imposed for the offence. Now, we will move to the third objective under preventive function of sentencing, that is rehabilitation. Sentencing with the aim of changing the attitude or behavior of an offender so that they do not commit the same or similar crime in the future is considered by the scholars to be the most ambitious development of penal theory. The ultimate goal of rehabilitation is to restore a convicted offender and enable him or her to play a constructive role in the society through the use of some combination of treatment, education, and training. The role of the modern state or the criminal justice system is to rehabilitate the offender rather than to avenge for the wrongful act committed. It is increasingly believed that the focus must be on the interest of the individual and the goal should be to salvage him for society. But applying these principles to a habitual offender is a matter of great concern. Communicative function of sentencing. While sentencing an offender, the sentencing court and thereby the criminal justice system is communicating certain messages to the society at large. This function of sentencing interacts in an extremely interesting way with the normative, distributive, and preventive functions of sentencing. The apex court in the case of State of Madhya Pradesh versus Bablu Nath clearly stated that the courts have an obligation while awarding punishment to impose appropriate punishment so as to respond to the society's cry for justice against such criminals. Public abhorrence of the crime needs a reflection through the court's verdict in the measure of punishment. The courts must not only keep in view the rights of the criminal, but also the rights of the victim of crime and the society at large, while considering imposition of the appropriate punishment. In the following year, in the case of Ankush Maruti Shinde and others versus State of Maharashtra, the Apex Court held that the law regulates a social interest, arbitrates conflicting claims and demands. Security of persons and property of the people is an essential function of the state. It could be achieved through instrumentality of criminal law. Undoubtedly, there is a cross-cultural conflict where living law must find answer to the new challenges, and the courts are required to mold the sentencing system to meet the challenges. The contagion of lawlessness would undermine social order and lay it in ruins. Protection of society and stamping out criminal proclivity must be the object of law, which must be achieved by imposing appropriate sentence. Therefore, law as a cornerstone of the edifice of order should meet the challenges confronting the society. Therefore, undue sympathy to impose inadequate sentence would do more harm to the justice system, to undermine the public confidence in the efficacy of law, and society could no longer endure under such serious threats. It is therefore the duty of every court to award proper sentence having regard to the nature of the offence and the manner in which it was executed or committed. Otherwise, it will send a wrong message to the members of the society and thereby destroy the faith in criminal justice system. This was again in detail discussed by the Apex Court in state of Madhya Pradesh versus Surendra Singh, whereby it was held that undue sympathy to impose inadequate sentence would do more harm to the justice system, to undermine the public confidence in the efficacy of law, and society could not long endure under such serious threats. It is therefore the duty of every court to award a proper sentence having regard to the nature of the offence and the manner in which it was executed or committed by the particular convicted person. A three-judge bench of the Supreme Court in Ahmad Hussain Wali Muhammad Syed versus State of Gujarat observed that the object of awarding appropriate sentence should be to protect the society and to deter the criminal from achieving the avowed object of law by imposing appropriate sentence. It is expected that the courts would operate the sentencing system so as to impose such sentence which reflects the concerns of the society, and the sentencing process has to be stern where it should be. Any liberal attitude by imposing meager sentences or taking too sympathetic view merely on account of lapse of time in respect of such offences will be result-wise counterproductive in the long run and against the interest of the society, which needs to be cared for and strengthened by string of deterrents inbuilt in the sentencing system. As a last note, protection of the society and deterring the criminal, the avowed object of criminal law can be achieved only by imposing a suitable sentence on the offender. While imposing the sentence, the sentencing judge should attempt to strike proper balance between the normative, distributive, preventive and communicative functions of the sentencing process. In the last 2 decades, a new movement has started getting wide momentum internationally and especially nationally through mainly judicial pronouncements in India for accepting restitution for the victim as one of the primary function of the sentencing courts. Challenges like inconsistency, disparity and the lack of fairness in the sentencing process that we are facing today in India are primarily due to lack of clarity among the sentencing judges relating to the functions of sentencing, and this is a major concern for the effective administration of the criminal justice system. It is high time to have structured guidelines in the sphere of sentencing to reduce the existing disparities and discrepancies in the sentencing process, and thereby to further curtail and restrict the influence of personal ideologies and preferences of the judges in affecting the sentence imposed. Thank you.